Right. Judge President, thank you again for talking to Anchored in Law. Now, you were then appointed as a judge of the Labour Court, first as an acting judge.
Yes.
Not so. When was that?
That was in 1997.
1997. That would have been during President Mandela's term.
Indeed.
Yes. What did he see in you?
Who?
President Mandela.
I don't think he saw anything. It's the recommendations that went to him.
Yes.
Well, I'd been pursued previously because I was like the current DCJ Zondo. My specialty was trade union law.
Yeah.
And when they were talking about setting up the Labour Court, the approaches were made to us to accept judicial appointment to that court. And I felt I was still a bit young and still had some debt, and didn't regard myself as judicial material. So I held out, until I agreed to act. I think around April or so, April, May of 1997, yes. And then I accepted a permanent appointment in October of that year.
What pushed you over the precipice? I mean, if you were so reluctant and you had debts to pay, there must have been something that
I was reluctant, but I think a number of advocates, Advocate Hans van der Riet, who I used to brief a lot, tried. They failed. John Mybeck, who was the first.
They tried to persuade you.
Yeah, tried to persuade me. I refused. And I think there must have been a discussion between John Mybeck and Edwin Cameron. Edwin Cameron was very close to us, remains close to me. And then I think he knew what button to press, and that button was to speak to my wife. Right, to say to my wife, hey, we're trying, we're failing. This man doesn't want to come here, and we think he's suited here. So I think my number was up when I got home, and that was it. My wife said, you must take this thing seriously,
But then you also doubled up, if I may put it like that, as a judge of the High Court at the time, didn't you?
No. That came afterwards. I'd been appointed permanently there in 1997, 98. And then towards the middle of 1998, the Deputy Judge President of the time here, I think it was Ilof, invited me to come and act here. Our JP then was former Chief Justice Ngobo in the Labour Court. So he released me. I came here. During my acting stint here, 6 judges, I think, Cameron, Nafsa, Goldstein, I think Schwarzman, I can't remember the other 2, nominated me because JP Ngwebe decided to advertise for this court. Right, whilst I was thinking this, they helped me decide by nominating me. Right, I went to the interview and I was appointed here in 1999. So I never went back to the Labour Court.
What is it, just a slight digression, what is it about labor law practitioners that makes them so good at what they do and very thorough in their work? I mean, I give you examples of, and I hope you don't take this as being condescending, yourself, Deputy Chief Justice Zondo, Justice Edwin Cameron, former Chief Justice Ngobo. They are colleagues, I don't want to embarrass them by mentioning their names also, who have cut their teeth in labor law, and they are excellent jurists. What is it about labor law, some young lawyers may want to find out, that equips lawyers to practice at the highest end and with the highest ability in law?
I think, talking for myself, and I've had this discussion with DCJ Zondo when we were in the Labour Court, we were acting for the weaker part in the labour scale. That is the workers and the trade unions. And the law was against them. So as their lawyers, your eye had to be on what the facts are. And most of the time, we dealt with illegal strikes. But our eye had to be, how do you beat the law and get something for these workers, you know. So you paid a lot of attention to detail, but at the back of your mind was trying to find strategies of getting around the legal hurdles that were there because of the laws that were there. I mean, if you remember, the conciliation board regime and whatever, when we got a good victory for the workers in the LAC, the law would be amended to change, to cover that gap. So we were continuously looking at that. So I don't know whether that makes us good, but it made us acutely aware that we have a client base that we need to assist, because it was more ideological than just doing work. It was more ideological to represent a sector that the law was against.
Yes,
you know?
no, that makes perfect sense. I suppose one can say the same thing about the lawyers who practice human rights law in the Legal Resources Center, for example. I find that people who come from these structures are very thorough lawyers and very accomplished.
Okay, thank you for that compliment. Yes. I also spent a year at the LRC.
Ah, yes, it shows. Now, Judge President, you then spent some time in the Supreme Court of Appeal from the High Court. Now, the Supreme Court of Appeal is, can I put it mildly and say, it's a strange creature, in the sense that I have found many colleagues of mine, myself excluded, of course, many colleagues of mine find it a bit of a challenge, or they view with trepidation the mere idea of appearing in that court. Many of them have told me that they'd rather appear in the Constitutional Court than appear in the Supreme Court of Appeal. Now, having spent some time in the serving on the Supreme Court of Appeal bench, why would you think that is?
Well, I've heard that kind of narrative being bandied around. And I can certainly talk about my own stint when I was there, acting and permanent. From the judicial perspective, I think there were serious issues about collegiality. I mean, there were big names there. I mean, for the first time in my life, I came across human beings who thought they were actually infallible. And they would want to dictate to you how to approach things, how to express yourself in your judgments. And some of them actually tried to instill a sense that don't try and look out for a constitutional point, because at that time there was a pushback against the Constitutional Court being...
It shows in some of the judgments of the time.
Yes, being the apex court. So you'd find a senior judge that you've drafted a judgment coming back to you and throwing the judgment at you and says, I don't see any relevance of the Constitutional Court judgment here and here and here. Please take it out. No, so that was happening. But more, I mean, collegiality was the issue. You would be the scribe and you would be the junior. And you'd write, give your best effort, and then all of a sudden you hear that a senior judge is circulating his own draft without talking to you to say what's wrong with your judgment. I mean, if you check on the judgments there, you'll see a number of my judgments where we'd conferenced, we'd agreed as a bench, that's the route, that's the law, those are the issues. You write according to that, but you still see another draft coming up. And I would refuse to withdraw my draft. I said, well, unless someone tells me what's wrong with my draft. Because as far as I'm concerned, it's in line with what we discussed. So there were a lot of collegiality issues. But some of those things played themselves out in court, where you'd find colleagues playing each other in terms of the questions they ask counsel, right? I mean, one would ask counsel a question that goes that way. Another colleague who doesn't agree would ask the same counsel a question that goes that way, as if they were playing each other. Those are things that used to happen. We tried, but we were junior. You know, no one would dare listen to us. But we tried to say, guys, this is not on. People spend monies to get their cases to get there. They require a proper and fair hearing. You know?
But wouldn't you regard it as a healthy disagreement where 5 judges sitting in the Supreme Court of Appeal disagree on a point or a couple of points of law,
Yes.
for that contestation to play itself out in court by the nature and the phrasing of the question put to counsel, isn't that a healthy debate?
I don't know. I don't think I agree with it. I think that there's a manner, the demeanor too, in how you ask the questions. Because to me, it borders on bullying.
Bullying who?
Bullying counsel.
Counsel.
Yeah, because then you check which judge is asking me which question, which one do I align myself with. You know, I don't think I would agree with that approach. I think judges are there to tease and ask and clarify issues or put propositions, not to play themselves out in glaring terms.
Yes,
you know?
yes.
Yeah.
No, okay.
You don't agree with me?
No. It's not for me to agree or disagree. I'm playing the role of a judge to tease out some issues with you. I have witnessed, having appeared in the Supreme Court of Appeal on a number of occasions, of some of my colleagues being really unfairly attacked. Not even being given an opportunity to state their case. I mean, there was an instance where the counsel is the respondent, for example, and the appellant stands up and he's told, no, I don't need to hear you, and they start attacking the respondent. I mean, one doesn't mind if the court understands the appellant's case, but has questions for the respondent to be asked to stand up and answer questions. But the manner in which the court on that occasion descended on counsel was a bit uncomfortable.
Yeah. No, I can tell you stories. I can tell you stories. I mean, I remember one case where I was on the bench. I was still junior. Advocate Vincent Maleka was on the receiving end of a barrage. But to his credit, he stuck to his guns. He said, I'm here, I'm going to argue, you're going to hear me out. And eventually he quietened them and they got to listen to him, you know. But someone weaker would have sort of folded. You know, I don't think that's correct. It's not our place as a judiciary to bulldoze counsel. Because counsel don't represent themselves. They represent litigants who expect justice from the court, isn't it?
Yes, no, absolutely. Now, you were quoted in a December, I think it was 2017, online publication as saying that you were a quote-unquote new generation judge. Now, I'd like to understand what you meant by that. As a judge in a courtroom, or in the manner in which you write your judgments, what do you mean by you're a new generation judge?
I think perhaps I can explain that the context in which I gave that answer was I was being interviewed for a leadership role in the judiciary. So I gave that answer in that context. But just to broaden it, a new generation judge, in my view, is one who does not just sit in his chambers and deal with what comes to him. I think it's and if you follow that interview, I said I'm not shy to pull my sleeves up and go and dirty my hands up.
Yes.
That you need to go behind what comes to you so that you get a better sense of what you are dealing with. That's what I meant. Because my experience is that you find that mostly judges will be happy with what comes to them and they'll just deal with things on that basis. There's another story somewhere else that may enrich your judicial decision-making process if you are aware of.
Give us an example of you dirtying your hands in the performance of your judicial function.
I think it applies more as JP, you know. I would go down and take a walk around the court here, you know, or in Pretoria. I mean, staff are usually surprised when they see me just walking down there. Or sometimes I won't use the passage. I'll walk across the road.
Sounds more like dirtying your feet.
Well, possibly. I'll walk across the road and go through the scanners where the security guards, those who don't know me, would search me. And I don't have a problem. Because that tells me, well, they're doing their work. And when I go out the same way to see whether they are searching the people who are leaving the court, because we're losing files, and we know that those files are being taken out of the building, right? So I experience those things myself. I go into registrars' offices, you know, like I see this is the issuing office. What is it that they do, right? Why do people get a problem when they want to have dates? I find that I'm better informed at understanding the processes. But in court, it never sits well with me if I have a litigant who is unrepresented, right, and facing a big legal team on the other side. I used to see that a lot during my labor court days, right? You find this is a poor worker. He's got a case, but because he's not represented, clearly the bench is going to be swayed against him, which is why I then said, no, let's establish pro bono help desks here and get the profession to operate on a roster basis where someone comes, a case, needs a lawyer, he gets a lawyer, he or she gets a lawyer, so that the bench gets a balanced view of the argument. You know, the equality of arms argument. So that's what I mean, in a sense. But it goes deeper into other things in terms of dating your hands. Like going and sitting in the roll call court of DJPs, you know, to see actually what happens, what kind of matters are called there, what do counsel get up to, you know. And I mean, we are unraveling what I call the RAF gravy train now, because we see that there's just a lot of rot that's coming to the courts, given to us under the guise of draft orders, right? So those, if you don't go behind the scenes to actually go down there and see what's happening, you'll simply continue give these draft orders
to push paper.
To push paper.
Now, I would like to move on to the next segment, where I would like to talk about activism as a judge. And we'll take it in the next segment.
Okay.
Okay.
No problem.
Thank you.